All right, hi everyone and welcome. Thank you for joining us today. I'm very excited to kick this session off. A few housekeeping things before we get started. As I think you probably all know by now, if you've participated in some of these sessions, there is simultaneous interpretation available to French and Spanish. And so if you'd like to access the interpretation, you can click the globe icon at the bottom of your Zoom screen, and you can select the language you'd like to hear us speak in through that. A quick note, if you have any questions or comments or anything you'd like to share throughout the session, we're happy to have those and we're happy to answer questions towards the end. We just ask that you please add your questions through the chat in the forum app, not in the chat on Zoom. So we'll be monitoring the chat in the app to take your questions. So please, if you have a question, make sure to share it there. I think those are all my housekeeping updates, so we can get started without further ado. So my name is Jessica Hickel. I'm a research officer at the Open Government Partnership, where I manage our research portfolio on justice and related topics. So I'm delighted to be speaking with you today here at the World Justice Forum, and also to welcome our excellent panel, who I'll introduce you to in a moment. So this session is intended to build on some of the great conversations we've had so far at the forum, focused on people-centered justice. And so I think when we're talking about justice, often conversations get centered around courts and kind of actors that we think of as being the justice sector. But I think what we have been talking a lot about in the past few days is that actually support for justice and accountability is happening at institutions far beyond the formal judiciary. And so I think, so the goal of our session today is to explore that a little bit by focusing on this idea of accountability as a part of justice, and to think about the institutions that are involved both in creating justice problems and then also providing justice solutions. So OGP has been attempting to think about this broader ecosystem of accountability institutions through some of our research, and specifically our new publication that we launched this week, which I'll share a bit more information about in a moment. But our publication looks at accountability broadly and the institutions that provide it, and thinks about these institutions as a form of justice and as actors in a justice sector in a broad sense. But before I dive in, I just want to say a few words about what OGP is for those who might not be familiar, and a little bit about what our work on justice has entailed and how it's evolved. So OGP is a partnership of 76 national governments and dozens of local governments. And we operate by allowing government and civil society in each member country or locality to work together to make commitments to improve government openness. And we think of openness as being transparency, participation, and public accountability. And so over the last decade that we've been around, our commitments have spanned a variety of topics, and justice is just one area of those topic areas, but it's one that's been growing a lot, especially in the last 3 to 4 years. And so our research on my team that we've done has reflected this growth. And so we've actually been working on what we're calling our justice policy series. And so it's 3 installments. The first 2 have been released in the last few years on access to justice and open justice. And you can access those on our website. And today we're going to be talking about the 3rd and final installment in the series, which is about this accountability piece. So I'll talk a bit more about that paper in a second, but first I want to highlight kind of a few of the factors that motivated this work and are motivating our conversation today. So for that, I'm going to share my screen. So I hope you will bear with me while I do that. I have quite a few screens going right now. So let's see. Okay, so this should be the correct one. And you should see a slideshow. Real quick, let me go to present. Okay. My screen is freaking out. There we go. So just what I wanted to highlight a bit is why we started thinking about accountability in this way, and kind of why we have created this push for it right now. So OGP tracks how relevant each of our thousands of commitments are to each of our values: access to information, civic participation, and accountability. And what you can clearly see in this graph is that accountability was never one of the more common focus areas of commitments, and it's declined over time. And so that's very concerning to us, especially in this context of democratic backsliding, of declining rule of law around the world. We think that accountability institutions and the ability of the public to hold officials accountable is kind of a backstop for democracy. And so we really want to encourage OGP members to be thinking more about involving this aspect of accountability in our commitments. So just to continue a bit about our publication and what we're going to be talking about today. So given this trend, given our concern for accountability, we want to focus today on talking about some of the institutions or the issue areas that we may not always think of as purely justice issues, but addressing, how and when and where citizens can go when they have challenges related to several areas. And so the paper focuses on 6 areas, which hopefully this QR code works and you can find them out for yourself. But they're focusing on issues of environmental rights, issues of access and disability rights, right to information and accountability for right to information requests. We're looking at voting rights and electoral dispute resolution, tax and fiscal justice, and then finally, anti-corruption and ways citizens can be using institutions to get accountability in cases of corruption. So you can access the full publication using this information here on the screen. But today we're going to dive deeper into a few of those topics with our excellent panelists. So I'm going to stop sharing my screen so that we can get started with this panel. Give me one moment to get my notes up here. Okay, so all right, so without further ado, I will introduce our panel, who are some of our excellent co-authors of this publication. And we are really excited that they were able to join us both in sharing their expertise in our publication and also here today. So today I'm joined by 3 experts. The first is Uchechi Anyanwu, who is a legal and anti-corruption officer at the Center for Anti-Corruption and Democratic Trust at the International Foundation for Electoral Systems. There, she manages a global anti-corruption project funded by the US government and supports the development of research, tools, and programming on legal, justice, and anti-corruption work. Our second panelist is Dr. Jason Lakin, who is a professor, researcher, writer, and manager with 15 years of experience in international development, teaching, and research. He is currently an associate professor at Zayed University's College of Interdisciplinary Studies, and previously he served as a senior research fellow at the International Budget Partnership. And finally, we have Sarah Wisanga, who leads Article 19's work in promoting and enabling legal policy and actual environment for transparency and information rights, including the right to information, freedom of expression, anti-corruption, and sustainable development in the East Africa region. She is passionate about the role of information in the modern age, particularly empowering a knowledgeable and informed citizenry to be a driver for sustainable political and economic development. So thank you 3 all so much for joining me. I'm excited to kick this conversation off. So I think our first segment here, we can start by talking a little bit about some of the barriers that you see when citizens are trying to access accountability on the variety of issue areas that you work on. And so my first question is for Uchechi, and I'm wondering if you can tell us a bit about what institutions are available to citizens in instances of alleged wrongdoing in elections? And what are the biggest challenges citizens face in calling for accountability at these institutions?
Thanks, Jessica, for the question, and thank you for the opportunity to speak on this topic today. So I think before we start talking about the institutions, kind of identifying them, setting them out, it's important for us to look at the role of these electoral dispute resolution, or EDR, institutions at all stages of the election. So we look at pre-election, we look at D-Day, election day, and we look at post-election. And I think what's also important when we talk about barriers to accountability is to define what accountability means in this context. So this probably goes without saying, but as the primary means by which citizens participate in government and hold their elected officials accountable, elections are central to the democratic system. So IFES looks at accountability as an essential principle of democracy that is based on an explicit set of rules and standards and reflects the popular will of the citizenry. So when we have elections, when we hold elections, they're generally considered credible if, one, the results accurately reflect the will of the people, and two, the stakeholders perceive the process, and remember we're talking about pre, D-Day, and even after, as credible, and they accept the results. So the citizens, the candidates, the political parties, basically the electoral stakeholders, believe an election was unfair or poorly administered, then they may not accept the outcome. So this is where EDR comes in, an effective EDR system, really. Elected officials and others who serve in democratic governments have an inherent responsibility to uphold fundamental human rights. And included in these fundamental human rights are the rights to political processes, to your right to vote, your right to associate. So these are amongst the fundamental rights that your officials are supposed to uphold. So to guarantee the protection of these fundamental democratic rights, it's essential to ensure that the integrity and the legality of every step of the electoral process. So EDR provides a means for addressing and importantly, resolving these disputes, irregularities, and other challenges at any point of the electoral process. So some of these institutions that have this mandate include electoral management bodies, or EMBs, campaign finance oversight bodies, courts, and specialized electoral tribunals. It's mostly commonly across the world for citizens to first go to their election management board. And this institution is usually the first instance of administrative jurisdiction. And they usually look at like pre-election disputes and violations, and sometimes post-election as well. If there is a right to appeal from the EMB, then the complainant may encounter the courts. Violations are not only administrative, so when we talk about maybe a criminal act or criminal violation, those are usually handled by law enforcement and by public prosecutors. So there are a number of barriers to EDR as an accountability mechanism that in the OGP publication, we've grouped under legal, practical, and institutional barriers. None of them are bigger or more important than the others, but they have differing impacts depending on the country that they occur in. Most importantly, I would say also is that each of these barriers highlight how any failure or barrier to any EDR process as an effective accountability mechanism can lead to an undermining of the democratic process. So I'll just briefly talk about two barriers, one practical, one institutional. So a practical barrier that we encounter in our work is centralized process. As we may know, either in our own experiences or kind of watching the electoral landscape in other countries, Accessibility is essential to overall perceptions of fairness and accountability of the electoral process and electoral institutions. But unfortunately, in some systems, EDR processes are inaccessible, and because of that, they tend to exclude vulnerable groups or other type of groups in the electoral process. So for example of how this comes about, an EDR procedure can be inaccessible when you have to travel outside of your community or your election constituency to file a complaint. So this has been the case in Myanmar and Pakistan, where in order for you to file an election results petition, you have to travel to the capital to do so. So this means also that any witnesses, your respondents, your petitioners also have to travel to the capital. And this means they may encounter costs like transportation or lodging, and these costs can be high. These costs also don't take into account the other costs like time that you may have to take off from work or time away from fulfilling family obligations. So these challenges, unfortunately, are made worse for women, people living with disabilities, and other vulnerable groups for whom reasonable accommodations are not made. So maybe there's no interpretation where they're going to file their complaint because they don't speak the language of that institution. Maybe they speak a local language and the institution speaks of the official language, or there are no assistive listening devices, or even just assessing the venue itself. So when we also look at institutional barriers, we look at limited training and capacity building of these institutions. So as I mentioned earlier, EMBs are usually the first instance of jurisdiction for some of these complaints. And unfortunately, EMBs are not always familiar with their quasi-judicial and mandates. So they're not able to resolve, or they're not capable to really investigate complaints that come before them. On the other hand, you also have some judges that, although they've received training, they may not have the technical knowledge to know about the different aspects of an election technically, or they may not be up to date on certain developments that have come up in the election fields. So because of this lack of knowledge or capacity on both sides or within these different institutions, this can also result in a lack of timely and relevant decisions. So, and unfortunately, without having this continuous education, this continuous capacity building, this continuous access to information, like I mentioned already, this can lead to inconsistent decisions, not only within an institution, but between institutions as well.
Great, thank you so much. That's it's really helpful for you to lay out all of that, and also a little discouraging to hear how many barriers there are in these processes, but helpful to think about this from all these different angles. One thing I want to pick up on is you mentioned this limited technical capacity, both on the part of institutions, but also on the part of citizens having knowledge of where to go for justice. And I want to use that, pick up on that, and transition to asking Jason a bit about tax and fiscal justice. So taxes are, as we all know, a very inherently technical, confusing area of the law and in general. And so what I was wondering in this respect, in your experience and in the research you've done, how do issues of capacity and technical knowledge factor into citizens' ability to get justice? And if so, how? And how does, and what kind of challenges does that create? And then also, if you could talk a bit also about if there are other challenges you see in terms of citizens using courts or other institutions to challenge tax issues.
Thanks, Jessica. And thanks for putting together the panel, and to my fellow panelists. It's great to be together. So probably capacity is one of these issues that will cut across many areas, and I think that's a good place to start. I want to say that when we think about justice in the tax and fiscal space, and this may be true for some other areas as well, but I think of it as there are sort of two aspects. One is a sort of individual aspect of an individual who is entitled to a public benefit or who is going to be assessed for taxes by the tax authority, and maybe feels that they are not getting the benefit that they're supposed to get, or that their tax assessment is unfair, and they want to challenge that. And so that's one kind of way to think about what a justice issue looks like in the sector. Another is more at the level of policy, and there we're thinking about the overall policy that determines who gets access to certain benefits or who's taxed what may be unjust or unfair, and somebody wishes to challenge that. And so there's overlap between these two things, but there's also some differences, I think. And so starting with capacity is one way to think about something which I think affects both aspects of the quest for justice in the tax and fiscal space. And of course, as you said, Jessica, tax and fiscal policy are areas that are notoriously complex and difficult for people to wrap their heads around. And we're at the intersection of that with the legal system, which is also complex, just means that this is a really hard area for many people to get involved in, particularly without access to support of some kind, whether it's legal aid or tax advice. Just going yourself and trying to navigate this can be very difficult for many citizens and tends to lock people out. I think we should also recognize that the sort of flip side to the capacity challenge is that when people do have the capacity or get the capacity working with civil society groups or advisors, that if they're able to afford that, there's still challenges in terms of accessing information. And so the government side of this is also important when we talk about capacity. It's the ability not just to understand the information, but to access the information that you need, whether that's the court cases, the legislation, the policy decisions, the precedents that you might need to put together a case that's often lacking, or it's only accessible to people with highly technical knowledge. So I think that's one of the important barriers. And probably closely linked to that is the issue of cost, which I think is cross-cutting for many sectors. We all know that accessing the legal system can be costly, accessing advice, legal counsel can be costly. In the tax space in particular, there's the additional obstacle that often, let's say you want to challenge an assessment, you're required to make a payment before you're allowed to access the tribunal. And so that's an additional challenge. Take an example of Uganda, you're required to pay 30% upfront of your assessment before you can challenge it. And so obviously that locks people out of being able to seek justice through the tax tribunal. In addition to these issues of cost, I think that in some contexts, the legal framework for challenging agency decisions is not as strong as it could be. So in some countries, the grounds on which an individual can challenge what a tax agency or another kind of public benefit agency is doing is not clear, is not clearly laid out in legislation that allows you to be certain that you can actually access judicial review for whatever the issue is. So you feel that you've been treated unfairly, but you're not sure on what grounds you can actually challenge that. And in addition, I think that sometimes the agencies that are relevant are actually not included. So for example, in a number of contexts, the tax authority has not traditionally been subject to the same rules for fair administrative action as other agencies, which just means that you can't review, some of the decisions are not reviewable in the same way that other agencies would be. So that can be a challenge. And when it comes to the more policy level challenges, when a public interest organization would like to challenge what a government's doing in terms of policy, not as an individual who's facing some unjust decision, but as looking at that policy as a whole and saying this is unjust for our society, then the issue of standing becomes important. Does that organization have standing to challenge on public interest grounds that legislation? And in many contexts, you do not. Organizations do not have that standing. And so it's only an aggrieved individual, and that makes it much more difficult to challenge policies as opposed to an individual decision. I guess the last thing I would just say is that all of these things that we've been discussing in the last couple of minutes are kind of ex post challenges to decisions that governments are making or policies that have been put in place. But of course, those policies in the first place may be unjust or unfair, in part because there was no public input into the development of those policies. And so, as in other areas where the government is open to public inputs, the policies that we end up with might be fairer or more just. And where that's not the case, and it is often not the case in the tax and fiscal space, then the policies themselves may be unjust. And so we know, just earlier this week, the International Budget Partnership released its new open budget survey showing that public participation around the world in public finance matters is very, very low. They scored it 14 out of 100, same as 2019, so also not improving. And in a context where the public in general and marginalized groups in particular are not able to raise their concerns in the development of the policy, then we're relying on ex post challenges to these policies, which face all the barriers that we just talked about. So opening things up earlier could potentially avoid some of those problems, but that the current state of affairs is not. And sorry to maybe not add to your optimism after Uchechi, but I think we'll talk about maybe what some solutions to this might be as well. So I'll stop there.
Great, thanks. Thanks so much. Really, really glad that you highlighted this part about involving citizens in the creation of policy and that being a way to preempt kind of all these other issues that arise later. I think that's something that when we're thinking about people-centered justice, that's a really important piece, is making sure that we don't create these justice problems in the first place. So that's great that you highlight that. I want to turn now to Sarah. So Sarah, with your expertise in right to information legislation and reform, this is an area where a lot of countries do now have clear frameworks for, maybe they're not so clear, but they have legal frameworks for citizens to be able to request information from the government. So given that the issue of having a legal framework is maybe not necessarily the barrier anymore in this area, what are the biggest challenges that you see for citizens to be able to access government-held information?
Yeah, thank you, Jessica, first of all, for putting this event together, and for my fellow panelists for kickstarting this conversation on such an engaging tangent. And indeed, you're right that over the past decade or so, we've seen a remarkable progress on the right to information. And currently, about, I think, 91% of the world's population lives in a country that has either a right to information law or policy. That is about 124 countries that have adopted comprehensive right to information laws. And about 29 countries at the moment either have a pending bill or some sort of initiative around the right to information. However, this is not the true pictures, because on the flip side, when it comes to right to information in Africa, only 25 countries have adopted right to information laws. This means only 66% of the African population lives in a country that either has a right to information law or policy. So if you compare this to the 91% of the global population, it shows that there's still a major disparity around the adoption of right to information laws, specifically across the continent. And so this sort of brings me to my first point on the barriers. And so the lack of a comprehensive legal framework continues to be a big challenge in achieving the right to information. And this isn't just for countries that lack any sort of form of right to information law, because what we've seen is that even in countries where the right to information is sufficiently covered in legal frameworks, a substantive barrier to the implementation is often the absence of either a policy or regulations that guide how then will the access to information law be implemented, or how to operationalize that specific legislation. For an access to information law to function effectively, there's always need for some sort of supplemented regulations specifying how these functions need to be implemented. So what we've seen is that when some countries do enact an access to information law or an access to information act, they do that first and then wait for, take the sweet time to develop regulations to operationalize this. And we've seen this taking 3, 4, even 5 years, like in the case of Uganda, their regulations are enacted 5 years, or in Kenya, where I am, our Access to Information Act was enacted in 2016. And up to now, we still do not have regulations to operationalize the act. So this continues to be a major barrier, also to speak. Another challenge that we've seen on the realization of access to information is often the limited awareness or knowledge gap about the right to information law. This has also been alluded to by both Jason and Uchechi on the knowledge and the awareness and the capacity. And what we've seen is this is twofold. It's both on the supply side and the demand side. I think, remember, most government entities, or even public bodies, and sometimes even private bodies that are performing public functions, they tend to operate in this sort of culture of secrecy. And so overcoming the culture of secrecy and sort of opaqueness is often the first challenge on the supply side. In Kenya, actually, there's even a term for it. It's called serikali. Government in Kiswahili is serikali, that means the government, but serikali means a strong secret. And so that's how a lot of these entities tend to operate. So overcoming this culture is usually a big sort of stumbling block on the supply side. And so after enacting or putting together an RTI legislation, a crucial factor in the implementation is usually, trying to generate that awareness amongst duty bearers, so they're able to basically understand their role and their mandate in facilitating the right to information as envisioned by the law. And so there's also need to create some sort of that similar awareness on the demand side, because what we've seen is quite often citizens, media, and even civil society very much struggle or lack the proper awareness or the capacity around right to information laws in their countries. And so this means that they are no longer, they're not generating demand in terms of information requests, or have a limited understanding on how the right to information is instrumental, in demanding for transparency, accountability, or even meaningful participation of citizens in governance. And so we also see this knowledge sometimes is not expanded or is not strengthened around sensitization on feedback, access to information, complaints or procedures, and also how then should their access to information requests be denied, how do they seek relevant appeals, or how do they what are the redress mechanisms in place for them. And then lastly, what we've also seen is that a number of jurisdictions are still struggling in setting up effective oversight, enforcement, or accountability mechanisms on the right to information. And this is often because in some countries, you find certain provisions within their right to information laws or legislation remain very open to the possibility of interference by either the executive or other government entities. And this is often caused when, the oversight and enforcement mandates are entrusted to individuals who are either within a government or a government agency. This means, in such countries, oversight and enforcement institutions are not independent. And another thing still under the same cusp is that in the region, what we've seen is cases where even when oversight and enforcement are placed within an independent commission, these commissions still struggle, with having resources like financial, technical, or human resources, because these are also very much dependent on the executive. So it's they're not in so such even independent agencies or independent commissions, if they're still dependent or lack the discretion to be able to use their funds, the discretion, to have to bring in people with the enough technical capacity or proper human resources, then it means they cannot effectively fulfill their mandate. And so for me, I think there are many other stumbling blocks or barriers to achieving the right to information. But in my experience, those are the main overarching sort of challenges. Thank you.
Thank you so much, Sarah. It's really interesting for me to hear too from the three of you who work in pretty different areas, how similar these barriers are across these different types of institutions. And so I think it's really interesting, and it also makes me wonder how or whether there are opportunities for learning between these institutions that often think of themselves as kind of separate from each other and with very different mandates. But maybe we can talk a bit more about that later. So now I want to transition kind of to our second conversation, which is the more optimistic conversation about solutions and cases where you've seen citizens have success stories in these areas, and kind of to start thinking about how OGP reformers or any reformers can kind of replicate those or implement them in their own context. So for this part, I'm going to go in reverse order. So sorry, Sarah, you're going to be talking again. But I was wondering, so you have a lot of experience working with civil society organizations on right to information issues. And so I'm wondering how in Kenya, in your experience, how have CSOs contributed to the progress of getting these RTI laws implemented? And what progress have you and others in your field made towards effective administration of RTI?
Yeah, thanks. The truth is that advocacy around implementing right to information in Kenya has always been a multi-stakeholder effort, with civil society, particularly under the OGP framework, being in the front lines. And so in 2016, after the enactment of the Access to Information Act, our focus mainly shifted to its implementation. And for civil society and even government, we had like three crucial factors to supporting this. The first one was being able to support duty bearers to be able to understand their role and the mandate as provided by law. And the second one was to create awareness amongst citizens and even knowledge amongst our civil society organizations. And then lastly was to support the oversight institution, which in our case is the Commission on Administrative Justice. It's nestled under our Ombudsman's office. And so we needed to support them in order to effectively fulfill their mandate. And so more specifically, since 2018, we've had an ongoing initiative to develop access to information regulations. And this has been a collaborative effort between the Commission on Administrative Justice and other entities like the Government Ministry of ICT, the National Law Reform Commission, but also civil society, including Organization Article 19, which is sort of a representative of the civil society organization at the technical committee level. And in Kenya's OGP fourth National Action Plan, which started in 2020 to 2022, what we did was we made sure to include the enactment of access to information regulations as a milestone under the Access to Information Commitment. And so almost 5 years after the enactment of the Act, it's only last year that we managed to publicize the draft regulations and call for input from the general public for them to be able to participate in the public participation process. And so as we speak, we've already received the feedback, we've consolidated the feedback, and what has happened is that the Commission has submitted the draft regulations to the Office of the Attorney General. And so we look forward for these regulations being fronted to the delegated parliamentary committees, but hopefully after the August elections, because literally our parliament is on its final leg as we speak. And another thing is in creating awareness around the right to information. Again, civil society partnered with the oversight body, the CAJ, to undertake very many awareness and sensitization training for public officers, and particularly within the counties, or what we call subnationals. And so in looking for a more sort of sustainable way to engage, or a sustainable means of intervention, Article 19, together with another civil society also under the OGP framework called the Local Development Research Institute, or LDRI, what we did is we collaborated, decided to come together with the CAJ and the Kenya School of Government to develop an access to information curriculum. So the curriculum, it's titled Access to Information in the Public Service. And it targets key implementers of access to information, including chief executive officers, information access officers, mid and top level directors, as well as like heads of human resources, and also complaints handling committees on access to information. And so we finalized the curriculum last year and even conducted a training of trainers. And I believe the first cohort of participants finished their training in February this year. And so we are just waiting for the official launch of the curriculum. And again, this was also a milestone that we had to put under access to information in our current OGP National Action Plan. And again, civil society, we've had a lot of cross-collaborative initiatives. I think one cross-cutting theme that you'll see here is when it came to access to information, we tried to get that multi-stakeholder collaboration as much as possible between civil society and government entities. And so we had civil societies developing like simplified versions of the Right to Information Act in order to improve the awareness among citizens. We also had regulatory bodies like the Media Council of Kenya also collaborating to produce a simplified media toolkit on access to information in Kenya. And under the OGP framework, by Article 19, we also convene what we call a media caucus on OGP that brings together media stakeholders from the OGP counties, or what they call OGP locals, not just to document or see what you are doing or publicize this, but as key implementing partners on access to information and other open governance initiatives. And lastly, as Kenya gears up for elections, which are set to happen in August, we've been working again collaboratively on electoral transparency, and our key focus has been on making sure the relevant stakeholders remain compliant to the African Commission guidelines on access to information and elections that were issued in, I think, 2017. And so the key stakeholders that we're working on are the media, the electoral management bodies, law enforcement, and other regulatory bodies to push for more credibility, transparency, and accountability during and after the forthcoming elections. So what I can say is that we still have a long way to go, but our key focus at the moment has been being able to safeguard the progress that we've made so far and try as much as possible to increase the momentum for the effective realization of access to information in Kenya. Thanks.
Great, thank you so much. And really interesting to hear how the commitment is progressing in Kenya, and hear more about how implementing through OGP has been working. I want to turn now to Jason, and to think specifically about, I know you've looked specifically at citizens using the courts for tax justice purposes. And I was wondering in these various contexts, if you could just describe some of these instances that citizens have successfully used litigation and judicial institutions to advance tax justice.
Yeah, thanks, Jessica. So a couple cases come to mind. One that we documented when I was at the IBP and has gotten a lot of attention in recent years is the Tax Justice Network Africa taking the Kenyan government to court over the use of double tax treaties. This case and a couple others are cases where organizations have taken advantage of more liberal standing requirements in Kenya since the 2010 Constitution. It's easier for public interest organization to go to court and challenge a tax law or tax treaty in this case, and basically argue that there are both, in that case, there were both procedural and substantive reasons why this tax treaty was should be thrown out. And many of these double tax treaties have been alleged to lead to revenue losses, essentially giveaways to large taxpayers without much compensating increases in investment or value, increase in employment or value for citizens. So initially, Tax Justice Network of Africa took the Kenyan government to court over a tax treaty with Mauritius. It took a few years, but they eventually, the courts did invalidate that treaty on procedural grounds. And that was a big win for Tax Justice Network Africa. Although the treaty was essentially renegotiated after that and re-implemented after that with Mauritius, it did establish for the first time that organizations could take issues like that to court and be successful, be treated as a legitimate party. And Tax Justice Network then went back to court on a number of other tax treaties. I think they followed up with a case on 10 additional tax treaties. So that legislation, that litigation ongoing, but I think that what that case shows is that if organizations are able to establish standing and overcome the sort of capacity and technical issues, which they did, sort of forming a coalition, drawing on the capacity of other actors in the context, forming an alliance with lawyers, the Katiba Institute in Kenya, to be able to push this case forward, then progress can be made. We have another case, which is still, I believe, still in litigation. I'm not up to speed on the latest of, in Colombia, where an organization called De Justicia has taken the government to court over lack of progressivity in the tax system, and they're using constitutional argument and basically saying the Constitution requires the tax system to be progressive, and the current tax system is not progressive, and so public interest litigation. Of course, the Colombian court is a very progressive court. There's a lot that has been able to be brought to that court over the last couple of decades. So not everyone can do what has been done in these cases, but I think what they point to are some of the enabling factors that are needed. So these are, to some extent, the flip side of what I talked about before. So if we have comprehensive legislation or legislative frameworks that clearly lay out the conditions under which judicial review is possible, as we do in, say, South Africa or Kenya now with administrative action acts, and Sarah also mentioned the ombudsman and having agencies that actually are in charge of implementing fair administrative action is important too. Then in those contexts, so passing legislation that is explicit and that expands the grounds on which public interest actors and individual citizens can bring cases is important. And we have legislation like that in South Africa and Kenya that can act as models. Liberalizing the standing requirements is important, and we have examples of that in different countries as well. For example, in Nigeria, the Fiscal Responsibility Act explicitly says that any individual can go to court without having to show a special particular interest and just try to enforce the legislation. So they're basically saying this is open to public interest groups to push for enforcement. I think the other things that matter are, we talked about access to information before, and that is important both in terms of what's the sort of general context of access to information, but also whether there are specific databases or resources that make it easy for citizens to identify case law that is relevant to putting together their courses, their cases, the kind of thing that Kenya Law Review does in Kenya, or private organizations do in some countries like the United States. We have Justicia that creates easy to use databases, and there's more that can be done. But and then the issue of cost that we talked about before, I think there's just last week, I believe, in Kenya, there was actually a case where not a case, but policy decision where the parliamentarians rejected a new policy from the executive to basically force citizens to pay upfront 50% of the costs, 50% of the assessment to move their cases to the High Court from the tax tribunal. And so these are the kinds of barriers that we talked about before, that we can make policy decisions to remove those barriers and make it easier for people to file cases. So the last thing I would mention is just the need for legal aid and different forms of support that so there's the cost, but there's also the support that citizens need. And there are some interesting examples recently of governments trying to provide pro bono support to citizens that have grievances in the tax system. So both Australia has set up a dispute assistance program, and Tanzania actually has set up a tax consultancy bureau that is supposed to help citizens who are not able to afford tax advice to contest the claims against them by the tax authority. And so governments can provide legal aid or other sort of innovative approaches to supporting citizens in these disputes that they may not otherwise be able to prosecute on their own.
Great, thank you. That's really interesting to hear about how in different contexts citizens can be using the courts for these issues, but also to know that these are also requires the right standing legislation to be in place and things like that. And so I think maybe later in the discussion we can talk a bit more about if reformers are facing a context in which they don't have access to those things, what are kind of like the next steps. But I think let's move to Uchechi, and then maybe we can talk a bit more about those those specific factors that are potentially enabling later on in the conversation. So I want to turn now to Uchechi. So Jason has talked about using the courts to advance tax justice, and I'm wondering if you can talk about in electoral disputes, is resolution, I know there have been more and more cases of election disputes being resolved through the courts. Do you see that as the most effective way always of resolving these issues? And if not, what would you say are or can be more effective ways of resolving electoral disputes?
Thanks, Sarah. I think Jason did a really good job of highlighting the importance of judiciaries in justice, whether it's tax justice or electoral justice. I think we've seen, especially in the last few years, how judiciaries have had to quickly adjust and implement rules and procedures that increase access to justice. I mean, we've seen remote and hybrid tools and modalities on the rise. And in the context of electoral justice and EDR, these have helped to ensure that there are limited delays or ensure that people have access to justice through the judiciary, where meeting in person or appearing in person isn't possible. But I think your question and several of the points that Jason and Sarah have raised really highlight a very important point, and that is, like other areas, for effective electoral dispute resolution, it needs a multi-stakeholder effort. Judiciary is great. It's a very integral part of the EDR process, but the judiciary is also not immune to the barriers that we've talked about today. In many contexts where IFIS works, we have judiciaries, or we've seen judiciaries face political interference and risks to their independence while trying to ensure electoral justice. So I guess one way that we can minimize these risks is we can have legislators, for example, ensure the autonomy of the judiciary through, let's say, their budget or staffing. So this could include ensuring the autonomy of judicial appointments, selections, and security of judges' tenure. EMBs also, where they're mandated, they could adopt some special procedures, allowing for both expedited and transparent EDR processes. As I've talked earlier, transparency and credibility of EDR processes is hugely important. So, election disputes are unique in that because there's this extra pressure to resolve a dispute quickly. I mean, elections occur within a set period of time. So there is this pressure to want to resolve them quickly. But because also when we talk about elections, there is this element of public interest in the outcome of these disputes. And given the public interest in election dispute resolution, governments can also ensure the implementation of transparency measures. So this could be, court or special tribunal. When they have their hearings, these hearings are open during the EDR process. And I think these points of openness and transparency and multi-stakeholder effort key in very much so into OGP and its tools and action plans. And I think this is also why IFES is a strong supporter of these action plans. We've helped in Guatemala in their last OGP action plan, we've helped them develop those. We're working in PNG on the implementation of theirs, and we have a focus on it in Albania. Because, looking at it ultimately, an open government leads to transparency. It leads to citizen participation. It leads to representation in political processes. And these are important not only for, governance generally, but in the election dispute resolution process. Thank you.
Great, thank you. And great to hear again some of the linkages across these areas, especially this idea of having a multi-stakeholder approach to achieving accountability. I want to we have about 30 minutes left, so I want to open it up for questions and comments from our audience, and remind everyone that you can do that using the World Justice Forum app. And I will hopefully be able to do two things at once and keep an eye on the chat. Let's see. I guess I would start by maybe kicking off with one of my own questions, and this can be for all our panelists, which is kind of thinking more concretely in contexts where reformers might be interested, especially on the civil society side, in advancing accountability in some of these areas, especially where legislation or at least public buy-in by public officials may be limited. What would you say are the immediate steps that they can take, or ways they can kind of get around some of the barriers we've talked about? And I'll just leave it very open-ended so you can take it however you'd like.
I can jump in to start. So, to some extent, this kind of question is gonna again be cross-cutting in that we, if the conditions are not right for you to do something, then you have to take a step back to the conditions before that and try to fix them. So, if the legislation is not adequate, then we need better legislation. So we're going to have to do advocacy to try and improve the legislation. And this can take a long time, but there may not be a shortcut. I guess, one thing and to a point that you raised earlier, Jessica, around standing, is that if, at least in the case of tax and fiscal, and if there are, if there's sufficient information available about previous cases and precedents, I mean, it depends on the legal system to some extent, but then individual claimants can still go to court and file cases that can have ramifications that go beyond that single case, even in the absence of, say, public interest litigation, to go after broader policies. And so that requires the kind of combined efforts that Cheche was just talking about, working together to identify a class of citizens, let's say, who we could work together with people who understand the law, people who understand the policies, and then trying to be strategic about which litigation to pursue, which cases to pursue that might sort of start to create precedents that can open the door to other challenges in the future. So if you, even in a situation where the legislation is not ideal, if you can get access to sufficient information and build some coalitions with the different kinds of expertise that are needed, I think you can still challenge unjust fiscal and tax policies, working through the courts. I mean, of course, working through Parliament is also important if you need to change that legislation.
I think for me, other than what Jason has just said around strategic litigation in Kenya, I think civil society have tried very much to be litigious around access to information. Front enough cases as much as possible, and actually, this has started, sort of yielding some sort of output, because sometimes one of the challenges is, even other than having like the absence of a specific legal framework, or despite having a comprehensive legal framework, you can find sometimes the implementation of certain policies tends to be very selective. So sometimes governments decide when and how what to implement. So being very litigious could be one. Another thing that we've managed to do to sort of circumvent certain barriers is to try this from, like they say, from the bottom up. And this is leaving the what some people tend to say a very saturated sort of space, that is where the capital, Nairobi, we're engaging with top level, high level government entities, and instead focusing on smaller community or county based sort of initiatives and partners, and even governments at the county level. And so we've managed, if you look at engaging certain entities, like for instance, in the case of Kenya, having the county assemblies forum who are focused on how certain laws and policies trickle down to the grassroots level. So trying it from the bottom up tends to give you some sort of stronger foundation, as opposed to tackling it from a high level sort of area, which and again, that is something that a lot of initiatives and even civil society have been accused of being very elitist, meaning they pick and choose and only engage high level people, and not necessarily people whom these laws tend to directly impact, people who are having this experiencing the direct impact of the certain laws or the lack of such laws. And then lastly would be that institutionalization of certain initiatives, at least in a lot of democratic spaces, at least in the African region, you tend to make certain progress, and then immediately there's a shift in either administration or political changes, then all the progress that has been made so far, whether legal or otherwise, tends to be dropped, and then you have to go back to the drawing board. So trying to have initiatives that are pegged on political goodwill tend not to be very sustainable. So trying as much as possible to not engage just in the politics of the day, but as much as possible to try and institutionalize the progress, make sure this is either put down in law or some sort of way to be able to make such interventions sustainable. In my opinion, is more would actually be able to help circumvent the pre-existing barriers. Thank you.
All right, to come up after Jason and Sarah have both raised very good points. I think Jason raised a very good point when he talked about, capacity. I think when it comes to elections, electoral justice, EDR, capacity is not just the technical part of it, but there's also an aspect of capacity that increases participation. Which goes into what Sarah has said about bringing it down to the local level. One of the barriers that I mentioned earlier really is having centralized processes, having people leave their constituencies, having them leave their communities to face processes that they may have very little knowledge of or interact with on a very little basis. So, you can look at one, building the capacity of maybe CSOs, the judiciary, other, electoral stakeholders to inform citizens to be, to increase their participation. Not only that, but bring down these processes to communities in a way that reflects the values and norms of those communities. This can also be not just looking at our formal EDR processes where we may go to an EMB or a court, but also looking at some other ways that we can look at maybe panels or committees at local level that engage with or have some kind of relationship with the EMBs to also resolve some of these disputes as well. A lot of what IFES does is not just in the formal system, but in the informal. So we also look at ADR and elections as well, and how we can have a holistic view at looking at electoral disputes and really how to resolve them in a way that prevents conflict, prevents disputes, and addresses them, some of the underlying issues as well.
Great, thank you. I'm keeping an eye on the chat to make sure we don't have any questions. Feel free, anyone, to come in. If also welcome anyone who wants to share their experience working on any of these issues. We can definitely make this a conversation. But I'll keep monitoring the chat. But if there's no other questions, then I'll just keep asking questions. And so I was wondering, and maybe this is, I feel like, there's no expert who knows the answer exactly to this, but I'm wondering, we're thinking about how similar the challenges and also some of the solutions are across these areas. I think something that we face a lot when talking about these issues across institutions is that a lot of these organizations and agencies don't necessarily see themselves as being an agency that deals with access to justice or is dealing with access to rights. Do you think that they need to be seeing themselves in that way, or how can we, are there ways we can encourage them to learn from each other in this particular space, despite the fact that they may be siloed otherwise in their mandates? That's a very big question that may be impossible to answer, but I'll give it all to you to see if you can begin to unpack that with me.
Okay, I think I'll try bite the bullet on this one. In our experience, especially oversight institutions, first of all, a lot is very much dependent on the goodwill, again, within those specific institutions, because you like it or not, they're political institutions. So I think one of the ways, in our experience, for instance, when we started engaging with the Commission on Administrative Justice, they've always seen, initially they had seen civil society as very combative, problematic, always stirring up, trouble. But just forming that sort of initial relationship for them to understand that we're both focused at the same end goal, sort of manage to quell those sort of combative emotions. And it's something similar that could be applied within such institutions, especially oversight institutions. Just understanding that at the end of the day, their mandate, whether or not it's coming from, it's what is entrenched in law, it's what is outlined in the constitution, or whatever civil societies are doing is one and the same, could be easier. And another thing is also being able to streamline and having some sort of coordinated form of engagement within such institutions, because they tend to operate as a monolith, as you said, as a silo, to each his own. But then you find that there are certain processes that are very intersectional. For instance, if you're speaking about access to information, you're going to engage with the institution that is in charge of sustainable development goals. You're going to engage with the institution in charge of universal UPR or something of that sort. Any institution that is in charge of overseeing the implementation, let's say, of the ICCPR, the constitutional provision. So these are very many institutions, but then again, the end goal is one and the same. So trying to find a way that provides us a structured and coordinated approach for them to understand that, despite their various mandates, the end goal is very much the same. I would say for me, it's a nice starting point. Thank you.
I definitely agree with Sarah on a point of coordination. I think we tend to look at some of these institutions as working in silos because they want to guard their work, but sometimes the issue is also there are too many hands in the pot. There are overlapping jurisdictions or overlapping mandates. So really having that coordination, that clarification in procedures and rules and mandates, I think it's also very important as well. I think another important aspect, and I mentioned it earlier as well, is that governments, elected officials, are supposed to uphold fundamental rights. So I think also distilling those rights and talking about those rights in ways that are not only approachable, understandable, but very much relevant to the work of these institutions. I think in a lot of cases, when we talk about rights, they seem very far-reaching. They're not very tangible. So I think another way to kind of, as a good starting point as well, is to when we talk about rights, what do we mean? When we talk about electoral justice, what do we mean about political rights? What do we mean about the right to vote in different parts of the process? What do we mean to, standing, as has come up a lot? I think it's very important to really contextualize these because they mean different things in different contexts. They mean different things to different institutions and their work.
Yes, and I have to go last. Well, I think maybe to not repeat things and maybe put a slightly different spin on it. I guess I'm thinking back to one of the things that we said in the case study that we did on the TGNA case, and that was that after the after the litigation ended and the treaty was thrown out, within a matter of, I don't know, it was a few weeks or a few months, the government had signed another treaty. And one of the things that we said at the time was that the one lesson from that case was that if you pursue, and I'm not saying that this is exactly what TJNA did, but if you pursue exclusively litigation approach to something, then you're not going to be able to engage with the broader political context, and you may end up failing to achieve your goals. And so what happened was that, this is a highly technical area. Not a lot of people understand double tax treaties or what's at stake in this discussion. And so you could maybe win a case at the court. A lot of people felt that the courts themselves didn't understand what was at stake. But anyway, you could win a case at the court on procedural grounds, as they did, but you sort of lose the broader fight because, there was no uproar when the government went back and signed another treaty, because for the most part, this was just not something that the broader public really understood. And so I bring that up to say that I think your question, Jessica, could also be interpreted in terms of the broader framing that we give to these different areas, and whether these areas are understood as impinging on the space of justice or the scope of justice. And so often, if we, it's easy to get lost in the technical details of a double tax treaty and say, well, this is a kind of complicated area and it's all about investment, and we lose track of what actually is at stake here, which is a developmental model and what it's going to mean for equity and what it's going to mean for justice in a broader sense. And I don't think we can expect the tax authority necessarily, or other agencies that are doing policymaking on their own to decide that, oh, this is, what I'm dealing with here is a fundamental justice issue. I don't think it's realistic to think revenue authorities, for example, are going to do that, which means that it's the responsibility of citizens to kind of come together in different ways and recast what these discussions are actually meant to be about. And so in that sense, I talked earlier about the fact that the governments don't provide a lot of opportunities for public participation and public finance. It's something we need to change. But I think that, ultimately, the formal opportunities that governments provide are one thing, and that's something that OGP is about, getting governments to make those kinds of commitments. But as Sarah was mentioning before, there's also just the civil society needs to take up the mantle of pushing this agenda, because we can't expect governments to, they might make a commitment, they're not going to follow up on that commitment. And when it comes to engaging in defining what, fiscal policy and tax discussions are really about, it's really going to fall back on citizens and citizen groups, citizen organizations, not individual citizens, to recast what these discussions are about, and then put the onus back on government to say, okay, well, if you're going to do that, whatever that is, you're going to do X, are you doing that in a just way? Because justice, broadly understood, is part of what this is all about, right? If you achieve some goal that you have, some policy goal that you have, but it's unfair, or it's discriminatory, or it leads to increased inequality, then you haven't actually done your job. And I think only sort of citizens organizing and taking advantage of legal instruments, but also kind of broader advocacy, that's the only way to make that a reality in most places.
That's really helpful to think about. Thanks. And I think this piece about, I think you mentioned it, Jason, and also Uchechi, about talking about these issues in a tangible, common language of rights is really important and interesting, because I think we all get in the weeds of our different area of expertise, and then we maybe don't express the very basic tangible nature of some of these issues. Let me double check our chat here. I want to follow up a little bit on, some of you have talked about kind of this coalition building among civil society and citizens in each of the areas that you work in. I was wondering if you could talk a bit more specifically about who are the most important actors to involve in these coalitions, and kind of for OGP, for anyone interested in kind of pulling these networks together, who should be involved, and how would you recommend kind of getting all of these people in the room?
I think I'll start. I'd say it depends on what exactly you're trying to achieve. For instance, when it comes to access to information, obviously, you look at the people who have been explicitly mentioned in the law, with regards to provisions of either access to information, like information access officers in our context, the oversight bodies, and then supporting bodies, because there's usually often like supplemental legislation that support the right to information. So it's very much dependent on the context, because if we are going to talk about right to information and water, the composition of the people that I'm engaging as stakeholders in the room is very different, as opposed to if I'm speaking to judicial transparency or access to information and elections. So even like in Kenya right now, we have access to information and sporting, actually, in the sporting area. So I would say being able to, first of all, map out who exactly is needed in that room is very much instrumental. Another thing is also make sure when you're building these coalitions, you actually have people who can, who have the mandate, the willingness and the ability to actually provide certain results. Because sometimes it's really nice and happy to have certain, let's say, government entities in the room, but they do not have those specific mandate to be able to accomplish certain thing. So making sure that you have the decision makers in the room, or people who are actually able to make certain decisions, would really actually help sort of push whatever agenda that you have. And then I would say lastly is also making sure when you're building certain coalitions in terms of civil society, again, it is not the same faces, because again, this is something that a lot of civil societies tend to be accused of when it comes to coalition building. If I mention, let's say, a civil society like Article 19, closing my eyes, I can tell 10 people who will automatically be in that room. It is good, but then being able to broaden that base of stakeholders so that it is not the same individuals, it's not the same organizations. You're allowing for new ideas, new opportunities, new collaboration, and new voices in the room. So that would be my take. Thank you.
I wouldn't add too much more to what Sarah said, but I think one important aspect when we talk about coalition building is to include as much as possible the groups of people that are excluded in the work in areas that we work in. I think in each of our areas of work, women are excluded, people with disabilities are excluded, also youth. And I mean, we work in areas where youth are a majority of our populations and have a lot of input to give into the decision-making process. So I think when we're talking about reforms, you want something different, we want change, right? So by actively including and engaging these perspectives that unfortunately are excluded, I think is one way to make sure that they're at the table, so the decision makers are aware of them, are aware of their perspectives, and there can be that coalition building around including their perspectives in these decision-making processes.
Yeah, I mean, as Cheshire was speaking, I was just thinking, that the answer to Jessica's question, I guess, is like to flip it around. I mean, who shouldn't be in the room? Who shouldn't we be engaging on these questions? I don't know. Probably there isn't anyone, but I think it's the need for broad coalitions that are inclusive that really are going to drive change. I would maybe just add, one other kind of interesting thing or slightly different thing from another case study I worked on a couple of years ago. In the Philippines, we looked at tax reform issue in the Philippines, and that was mainly around tobacco tax. But there's a couple examples like this where I think one of the interesting things that happened in that case and in others is that professional associations got involved that were not typically involved in these kinds of discussions. And so in that case, help medical professionals who are not really tax experts, but they understood the importance of tobacco tax or sin taxes. And one of the things they were able to do, which relates to what we've been talking about, is to just change the framing in the discussion and provide some more depth and connection for people to an issue that was otherwise maybe a little bit ethereal or hard to connect to. And so I think there is potential, and these are often large networks, depends on the country and depends on the area, but of whether it's medical professionals in that case, but accountants themselves. In other cases, you have other kinds of associations that are maybe relevant and different for different issues, and can just allow you to reach different actors and change what the conversation is about a bit, change the face of the kinds of people that are talking about something. So yeah, just wanted to add that.
That's
and
really
sorry, I couldn't help but noting, Jessica, that when you asked your question, right at the moment that you asked your question, I got a message from the app saying lunch is in 10 minutes. So keep track of the important things.
Yes, well, we only have 3 minutes until lunch. So, but thank you. This has been an amazing, amazing conversation. Just maybe to close out, I was wondering if you could each give like a quick 30 seconds. What is, one thing that you'd like to see happen in the next year or so in the areas that you work in? Like, what is your wish list, or, a thing that needs to get done, or anything and just a quick closing. Not to put you on the spot, but maybe we can start with Uchechi.
Wow, okay. 30 seconds, right? Okay. I think I would like to see that when we talk about electoral dispute resolution, we really look at the so-called informal ways of resolving electoral disputes. Really ones that engage the community, engage norms. And I would also like to see more information, more data. I think when we talk about access to information and want to improve things, sometimes that information doesn't exist, or it doesn't exist in a way that we can make sense of it. So I think if it could happen in the next year, great, but I would like to see some steps in that direction.
I don't know if you're going to tell us what order to go in, Jessica, but I can go next. Before Sarah says everything. I think I would like to see, I think that there are interesting cases, a couple like the ones I mentioned, the TJN case, the Justicia case in Colombia. And I guess I'd like to see more strategizing across the globe around. So, strategic litigation is strategic. It's normally a discussion that happens at the national level, looking at the sort of the nature of the legal system, and that's obviously necessary. But I think there's also opportunities for learning across countries about the approaches that people take, and there's enough similarities, at least within certain groups of countries in the legal system, to allow for more of these challenges. And as Sarah was kind of saying about access to information earlier, more challenges, the more challenges there are, the more kind of there is to draw on. If you make the wrong choices, you can also get bad rulings, and that can hinder you. But generally, more for us to learn from and to borrow and to share with each other.
Okay, pretty quick, because I can see our time is up. For me, I have a very long wish list, but I'll just limit it to 3 things. Number 1 is obviously, a more enhanced, proper legislative framework around access to information in the countries that are still struggling with this. Obviously, the second one is that demand, because again, what's the need to have this law in place if we're not generating, citizens are not generating that demand. And I think lastly, it would be accountability, because again, we've had so many issues around transparency, access to information. We've managed to get corruption and all that, but unfortunately, at least in the African context, we rarely see people being held accountable for whatever it is that they've been found guilty of. So those are like my three main things. Thank you.
Great. Thank you so much. And thank you for a wonderful discussion. It's been great to chat with all of you. And I think with that, we can close out for the day. I just want to put in one last plug to please do check out the publication. Jason and Uchechi both wrote very interesting chapters for our publication. So we encourage you to check that out. And thank you and have a great rest of your day.